This audio case is brought to you by Laudio. This is Farwell versus Keaton. The opinion is given by Justice Levin. There is ample evidence to support the jury determination that David Segrist failed to exercise reasonable care after voluntarily coming to the aid of Richard Farwell, and that his negligence was the proximate cause of Farwell's death. We are also of the opinion that Segrist, who was with Farwell the evening he was fatally injured, and, as the jury found, knew, or should have known of his peril, had an affirmative duty to come to Farwell's aid. On the evening of August 26, 1966, Segrist and Farwell drove to a trailer rental lot to return an automobile which Segrist had borrowed from a friend who worked there. While waiting for the friend to finish work, Segrist and Farwell consumed some beer. Two girls walked by the entrance to the lot. Segrist and Farwell attempted to engage them in conversation. They left Farwell's car and followed the girls to a drive-in restaurant down the street. The girls complained to their friends in the restaurant that they were being followed. 6 boys chased Segrist and Farwell back to the lot. Segrist escaped unharmed, but Farwell was severely beaten. Segrist found Farwell underneath his automobile in the lot. Ice was applied to Farwell's head. Segrist then drove Farwell around for approximately 2 hours, stopping at a number of drive-in restaurants. Farwell went to sleep in the back seat of his car. Around midnight, Segrist drove the car to the home of Farwell's grandparents, parked it in the driveway, unsuccessfully attempted to rouse Farwell, and left. Farwell's grandparents discovered him in the car the next morning and took him to the hospital. He died 3 days later of an epidural hematoma. At trial, plaintiff contended that had Segrist taken Farwell to the hospital, or had he notified someone of Farwell's condition and whereabouts, Farwell would not have died. A neurosurgeon testified that if a person in Farwell's condition is taken to a doctor before or within half an hour after consciousness is lost, there is an 85 to 88% chance of survival. Plaintiff testified that Segrist told him that he knew Farwell was badly injured and that he should have done something. The jury returned a verdict for plaintiff and awarded $15,000 in damages. The Court of Appeals reversed, finding that Segrist had not assumed the duty of obtaining aid for Farwell and that he neither knew nor should have known of the need for medical treatment. 2 separate but interrelated questions are presented. A. Whether the existence of a duty in a particular case is always a matter of law to be determined solely by the court, and B. Whether, on the facts of this case, the trial judge should have ruled as a matter of law that Segrist owed no duty to Farwell. A duty in negligence cases may be defined as an obligation to which the law will give recognition and effect, to conform to a particular standard of conduct toward another. The existence of a duty is ordinarily a question of law. However, there are factual circumstances which give rise to a duty. The existence of those facts must be determined by a jury. In Bonin v. Gralowitz, this court reversed a directed verdict of no cause of action, where the trial court had determined as a matter of law that the proofs were insufficient to establish a duty of care. Quote, usually in negligence cases, whether a duty is owed by the defendant to the plaintiff does not require resolution of fact issues. However, in some cases, as in this one, fact issues arise. When they do, they must be submitted to the jury, our traditional finders of fact, for ultimate resolution, and they must be accompanied by an appropriate conditional instruction regarding defendant's duty, conditioned upon the jury's resolution of the fact dispute. End quote. This same rule was stated more recently in Davis v. Thornton. The trial judge in this case determined the defendant owed the plaintiff no duty. We believe this conclusion could properly be made only by a jury. Without regard to whether there is a general duty to aid a person in distress, there is a clearly recognized legal duty of every person to avoid any affirmative acts which may make a situation worse. If the defendant does attempt to aid him and takes charge and control of the situation, he is regarded as entering voluntarily into a relation which is attended with responsibility. Such a defendant will then be liable for a failure to use reasonable care for the protection of the plaintiff's interests. Where performance clearly has been begun, there is no doubt that there is a duty of care. In a case such as the one at bar, the jury must determine, after considering all of the evidence, whether the defendant attempted to aid the victim. If he did, a duty arose, which required defendant to act as a reasonable person. Before any duty or any standard of conduct may be set, there must first be proof of facts which give rise to it. Whether those facts have been proved is a question for the jury. Professor Green argues that it is impossible in the nature of things for the duty problem to be decided by the jury. For if the court sends the issue to the jury, this necessarily operates as a ruling that there is a duty, or else he would never have submitted the case to the jury at all. But that is not so. As in the case of any other issue, the judge will leave the question to the jury if it is a debatable one. But the jury may decide that, for example, plaintiff was beyond the apparent scope of danger from defendant's conduct, and so beyond the scope of the duty to perform it carefully, even where they are quite ready to find defendant's conduct clearly below the standard of reasonable care. There was ample evidence to show that Siegrist breached a legal duty owed Farwell. Siegrist knew that Farwell had been in a fight, and he attempted to relieve Farwell's pain by applying an ice pack to his head. While Farwell and Siegrist were riding around, Farwell crawled into the back seat and laid down. The testimony showed that Siegrist attempted to rouse Farwell after driving him home, but was unable to do so. In addition, Farwell's father testified to admissions made to him by Siegrist. Q. Witness, just before the jury was excused, I asked whether you had any conversation with Mr. Siegrist after this event occurred. You answered, yes, the day after, in the living room of Mrs. Grenier's, the deceased mother's, home. Then, the jury was excused, and we made a special record, and now I would like to ask you some questions that I asked and that you answered out of the presence of the jury. A. Yes. Q. What did Mr. Siegrist say? How did the conversation go? A. I asked him why he left Ricky, the deceased, in the driveway of his grandfather's home. Q. What did he say? A. He said, Ricky was hurt bad, I was scared. I said, why didn't you tell somebody, tell his grandparents? He said, I know I should have, I don't know. The question at trial came down to whether Siegrist acted reasonably under all the circumstances. The law of negligence is that an actor is held to the standard of a reasonable man. The determination of the facts upon which the judgment of reasonableness is based is admittedly for the jury. The jury, in this case, found that Siegrist did not act reasonably, and that his negligence was the proximate cause of Farwell's death. In considering the question whether defendant was entitled to a directed verdict, the testimony must be construed as strongly as possible in favor of the plaintiff. The specific inquiry is whether this court can say, as a matter of law, giving to plaintiff's proofs the strongest probative force to which they are entitled, that the evidence was not sufficient to justify submitting to the jury the questions of defendant's negligence and its knowledge or notice of the situation. Siegrist contends that he is not liable for failure to obtain medical assistance for Farwell because he had no duty to do so. Courts have been slow to recognize a duty to render aid to a person in peril. Where such a duty has been found, it has been predicated upon the existence of a special relationship between the parties. In such a case, if defendant knew or should have known of the other person's peril, he is required to render reasonable care under all the circumstances. In N.W.2d v. Fladow, the Supreme Court of Minnesota reversed an order of the trial court dismissing the cause of action, and said that if the defendants knew their dinner guest was ill, it was for the jury to decide whether they were negligent in refusing his request to spend the night and propping him on his wagon with the reins thrown over his shoulder, sending him toward home. The Sixth Circuit Court of Appeals in Hutchinson v. Dickey said that a host had an affirmative duty to attempt to rescue a guest who had fallen off his yacht. The host controlled the only instrumentality of rescue. The court declared that to ask of the host anything less than that he attempt to rescue his guest would be so shocking to humanitarian considerations and the commonly accepted code of social conduct that the courts in similar situations have had no difficulty in pronouncing it to be a legal obligation. Farwell and Siegrist were companions on a social venture. Implicit in such a common undertaking is the understanding that one will render assistance to the other when he is in peril, if he can do so without endangering himself. Siegrist knew, or should have known, when he left Farwell, who was badly beaten and unconscious in the back seat of his car, that no one would find him before morning. Under these circumstances, to say that Siegrist had no duty to obtain medical assistance, or at least to notify someone of Farwell's condition and whereabouts, would be shocking to humanitarian considerations, and fly in the face of the commonly accepted code of social conduct. Courts will find a duty where, in general, reasonable men would recognize it and agree that it exists. Farwell and Siegrist were companions engaged in a common undertaking. There was a special relationship between the parties. Because Siegrist knew or should have known of the peril Farwell was in and could render assistance without endangering himself, he had an affirmative duty to come to Farwell's aid. The Court of Appeals is reversed, and the verdict of the jury reinstated. Kavanaugh, C.J., and Williams, J. concur. Lindemeyer and Ryan J.J. not participating. Justice Fitzgerald dissents. The unfortunate death of Richard Farwell prompted this wrongful death action brought by his father against defendant David Segrist, a friend who had accompanied Farwell during the evening in which the decedent received injuries which ultimately caused his death 3 days later. The question before us is whether the defendant, considering his relationship with the decedent and the activity they jointly experienced on the evening of August 26th through 27th, 1966, by his conduct voluntarily or otherwise assumed or should have assumed the duty of rendering medical or other assistance to the deceased. We find that defendant had no obligation to assume, nor did he assume, such a duty. The facts of the case are accurately set forth in the Court of Appeals opinion. Factually, it appears that on August 26, 1966, Richard Murray Farwell, deceased 18-year-old son of the plaintiff, visited the home of his friend David Segrist, a 16-year-old. That evening, they drove to a trailer rental lot, where Segrist was returning an automobile he had borrowed from a friend who was employed by the rental agency. Segrist and Farwell planned to wait in the car until the friend had finished work and then drive around, stopping at various restaurants and drive-ins. While they were waiting, Segrist estimated that they consumed 4 or 5 beers each. Shortly before 9 o'clock p.m., 2 teenage girls walked past the car. After an unsuccessful attempt to engage them in conversation, Farwell left the car and followed the girls. Segrist got out of the car and followed Farwell. When the girls reached a restaurant a short distance down the street, they apparently complained to those present that they were being followed. Defendants England, Brock, Donald Keaton, Daniel Keaton, and at least 2 others in the restaurant began to chase Farwell and Segrist, both of whom ran back to the trailer lot. Segrist escaped by ducking into the trailer rental office, where he requested those inside to assist Farwell. They stepped out of the office and were confronted by the group which had been chasing Segrist and Farwell. The 2 groups faced each other, but no violence ensued, and the 2 groups scattered. It was then discovered for the first time that Farwell had been caught and beaten by those who had been pursuing him and Segrist. Farwell was found underneath his automobile in the lot. Farwell was taken to the trailer rental office, where Segrist gave him a plastic bag full of ice for his injuries. Shortly thereafter, Farwell and Segrist left the rental office, and between 10 o'clock p.m. and midnight, they visited 4 different drive-in restaurants. While en route from the 3rd to the 4th restaurant, Farwell stated that he wanted to lie down, climbed into the back seat, and went to sleep. Around midnight, Segrist drove the car to the home of Farwell's grandparents, parked it in the driveway, and attempted to rouse Farwell. When the latter merely made a sound, as if in a deep sleep, Segrist left with a friend who had followed him to the grandparents' house. The next morning, Farwell was found by his grandparents, apparently taken to a hospital, and died of an epidural hematoma. At the close of plaintiff's proofs, defendant Segrist moved for a directed verdict on the grounds that he had no duty to obtain medical assistance for Farwell as a matter of law. In the alternative, the motion was based upon the proposition that plaintiff failed to establish that any conduct on the part of Segrist proximately caused Farwell's death. The motion was denied. Following the jury verdict of $15,000 in favor of the plaintiff, defendant, arguing that the verdict was inconsistent with the weight of the evidence, moved for and was denied a judgment notwithstanding the verdict. The decision of the trial court was reversed by the Court of Appeals, which found that the defendant never assumed, voluntarily or otherwise, the duty of obtaining medical assistance for the deceased. The court stated that the facts in no way indicated that defendant knew or should have known that immediate medical attention was required. Consequently, as a matter of law, the court determined that defendant was under no duty to obtain medical treatment for the decedent. Plaintiff argues that once having voluntarily undertaken the duty of caring for decedent, defendant could not discontinue such assistance if, in so doing, he left the decedent in a worse position than when such duty was assumed. Defendant's knowledge of the seriousness of decedent's injury and the failure to advise decedent's grandparents, the close personal relationship that existed between defendant and the decedent, and the supposition that the decedent relied upon defendant for assistance, leads plaintiff to conclude that defendant did not act with the reasonable prudence and care of a reasonable man in the same or like circumstances. Defendant's position is that there was no volunteered assumption of duty to care for the safety of the decedent. He argues that the facts within his knowledge on the evening of August 26, 1966, and the evidence introduced at trial failed to establish that defendant should have seen that Richard Farwell had suffered a potentially fatal injury requiring immediate attention. Defendant did not voluntarily assume the duty of caring for the decedent's safety. nor did the circumstances which existed on the evening of August 26, 1966, impose such a duty. Testimony revealed that only a qualified physician would have reason to suspect that Farwell had suffered an injury which required immediate medical attention. The decedent never complained of pain, and in fact had expressed a desire to retaliate against his attackers. Defendant's inability to arouse the decedent upon arriving at his grandparents' home does not permit us to infer, as does plaintiff, that defendant knew or should have known that the deceased was seriously injured. While it might have been more prudent for the defendant to ensure that the decedent was safely in the house prior to leaving, we cannot say that defendant acted unreasonably in permitting Farwell to spend the night asleep in the backseat of his car. The close relationship between defendant and the decedent is said to establish a legal duty upon defendant to obtain assistance for the decedent. No authority is cited for this proposition other than the public policy observation that the interest of society would be benefited if its members were required to assist one another. This is not the appropriate case to establish a standard of conduct requiring one to legally assume the duty of ensuring the safety of another. Recognizing that legal commentaries have expressed moral outrage at those decisions which permit one to refuse aid to another whose life may be in peril, we cannot say that, considering the relationship between these two parties and the existing circumstances, defendant acted in an unreasonable manner. Plaintiff believes that a legal duty to aid others should exist where such assistance greatly benefits society, and only a reasonable burden is imposed upon those in a position to help. He contends further that the determination of the existence of a duty must rest with the jury, where questions of foreseeability and the relationship of the parties are primary considerations. It is clear that defendant's nonfeasance, or the passive inaction or a failure to take steps to protect the decedent from harm, is urged as being the proximate cause of Farwell's death. We must reject plaintiff's proposition, which elevates a moral obligation to the level of a legal duty, whereas here, the facts within defendant's knowledge in no way indicated that immediate medical attention was necessary, and the relationship between the parties imposes no affirmative duty to render assistance. The posture of this case does not permit us to create a legal duty upon one to render assistance to another injured or imperiled party where the initial injury was not caused by the person upon whom the duty is sought to be imposed. The relationship of the parties and the question of foreseeability does not require the jury, rather than the court, determine whether a legal duty exists. We are in agreement with the general principle advanced by plaintiff that the question of negligence is one of law for the court only when the facts are such that all reasonable men must draw the same conclusion. However, this principle becomes operative only after the court establishes that a legal duty is owed by one party to another. Prosser's analysis of the role of the court and jury on questions of legal duty, recently quoted in Moaning v. Alfono, Michigan, bears repeating: the existence of a duty. In other words, whether upon the facts in evidence such a relation exists between the parties that the community will impose a legal obligation upon one for the benefit of the other, or, more simply, whether the interest of the plaintiff which has suffered invasion was entitled to legal protection at the hands of the defendant. This is entirely a question of law, to be determined by reference to the body of statutes, rules, principles, and precedents which make up the law, and it must be determined only by the court. A decision by the court that, upon any version of the facts there is no duty, must necessarily result in judgment for the defendant. Michigan recognizes that the question of duty is to be resolved by the court rather than the jury. The Court of Appeals properly decided, as a matter of law, that defendant owed no duty to the deceased. We would affirm. Coleman J. concurs. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.